pen. So to say in this one instance that having the legislature take action would be a violation of separation of powers is not in line with the principles. And it's something that then would be violated. It's a recursive argument because it would be violated in every single act of the legislature pretty much, or at least 95% of them, because that's what they're doing most of the time is they're instructing the executive branch to execute the laws that they create. So,
and I appreciate that, Mr. Secretary. The veto power is in the Constitution, and I vetoed the bill, and so we do not have that bill here. I vetoed it for the reasons that I said. Those arguments that you've advanced are ones that are cogent and thoughtful, and I think they probably can come up in this next session, and we may be faced with the same thing. But I appreciate your comments. I think we're really talking just about the amendment, and I do apologize for taking up the time here for those who are really serious about wanting to consider these things. And I appreciate the Secretary's comments, but I especially appreciate the diligence with which the auditor and superintendent have proceeded. So, Madam Auditor.
Mr. Chairman, I would move that we begin the regular rulemaking process with the draft rules put forward by the Rules Working Committee, and that would be enacted today. And Suzanne, please help me out if I don't, sorry, Secretary, help me out if I don't get the motion exactly correct, but I would move the proposed set of rules as we have before us.
Second.
Been moved and seconded. Is there any discussion?
Yeah, Mr. Chairman.
Mr. Treasurer.
Just some brief clarity, I guess, and wondering how these rules interact with your agreement with the, how these rules interact with your agreement with the legislature. It seems like in these rules, we're in, I guess, commingled property, so to speak. And now, is there another set of rules or another chapter that would be more appropriate to have the non-commingled property placed in, or how do you think we should proceed with this? Because I'm a little bit concerned about putting everything in one chapter if it's dealing with an authority that's just the executive branch and not the legislative branch, where these are both, from what I can tell.
Madam Auditor.
Mr. Chairman, great question, Treasurer, and I think you get at part of the heart of the issue is that the statute is so prescriptive and draws a lot of wiggly lines and whatnot. And so I think where this is the operation and use of public buildings, I do believe that Chapter 4 is the best place for them. Okay. However, we can't get around the slightly messy but prescriptive statute. So essentially, we pass these for areas over which we have control or over which there are shared use. But of course, the statute for now, the statute controls, but then once if management council were to choose to act, then we don't have to go in and change these.
Yeah, I think, yeah, Mr. Chairman, I think the other area that we need to look at that really isn't called out in here is the auditorium. So I think we have both the Hirschler building and the auditorium as far as this capital complex, but the capital extension necessarily doesn't include, may or may not include the auditorium, and it doesn't include the Hirschler building. So, yeah, I think there's a...
Mr. Chairman, yeah. Treasurer Meyer, we did discuss this and also in our briefings. And as the auditor mentions, there's lots of things that are a little confusing with this, but at this time, this is public areas and we haven't written the rules to allow carry within governmental meetings until that law is repealed.
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. And Treasurer, I think you're asking the precise question and why we are where we are today with what we're discussing. And that's what the auditor and I have been really working through, right? You have a law on the books around meeting rooms, and so this constitutes a meeting room. We have separate rules that constitute the Hirschler building and our office buildings. And so while the easy approach is to just quick throw everything in a bag, what we're really trying to do is make sure that we effectively allow for constitutional carry in all of these buildings. And so that's why we're seeing this phased approach, and we'll be bringing to you that next iteration as soon as we can with changes that need to be made with the legislative branch and then that we can make within the rules.
I look forward to that, thank you. I have no more questions.
Thank you, Mr. Treasurer, and just in the future, I didn't realize your microphone was not on, so, thanks. Further questions?
Well, Mr.
Secretary.
Chairman, I want to bring my amendment.
Yep.
Well, thank you, Mr. Chairman. I would like to move the amendment here to add in the Hirschler building. It is on your desk. It's a pretty simple forward amendment. Because of the color, it's a black and white here. It's that highlighted section. So it's the addition of that and then the cross out of and before the capital extension.
Okay. The
It
Secretary.
does not
has-
cross out the capital extension, it just crosses out the word and.
Right, I appreciate that. And the Secretary has brought his proposed amendment. Is there support for the proposed amendment? Is there support for the proposed amendment? Is there support for the proposed amendment? Mr. Secretary, that motion fails for lack of a second. And I will say I appreciate your comments on that.
Well, Mr. Chairman, I'd like to make a couple comments here
Sure.
as we proceed to a vote. You know, I certainly am going to vote for this. I think this is a step in the right direction. But the reality is that we just continue to slow walk real conservative reforms in our state. And this is just another example of it. And, you know, you can continue to question my motives and say, I'm a bad guy, which seems to be, you know, and I don't have a good intent. I'm just trying to, as you said, get publicity, which violates the civility rules that you've put forward. But the reality is there are people in the Hirschler building that are concerned for their safety because there have been threats to offices in the Hirschler building, which you've acknowledged in text to me. And I've been working on this for 2 years, trying to get this over there, reaching out to you on this process before it was even rebrought in the legislature. I mean, we've been working on the legislature since 2017. And it's very disappointing that we didn't get it done in the Capitol complex in the full areas that we have jurisdiction over. There is no problem with the EO. That is incorrect. Just like the legislature didn't require the removal of the EO, the legislation, the rule wouldn't either. The rule supersedes the EO for a variety of reasons. And so it's very important that we address this, but it is good that we can finally get it in certain areas. I think getting the word out on this is going to be interesting because certain areas of the Capitol, it's going to be allowed during the session, and certain areas it's not. I presume because we're going to have a meeting in February in the middle of the session to actually presumably adopt these rules. So the reality is we need to have that broad-based reform, not just trying to dither and delay, do the bare minimum possible. That being said, going to vote aye because it does advance the ball in a certain way. Thank you.
Thank you, Mr. Secretary. I'll just note that comments like dither and delay and slow walk are also characterizations of motives, just for the point. Any further discussion? Question's been called. All in favor signify by saying aye.
Aye.
Nays? All right, I'm going to do that roll call. I thought I heard an aye from you.
Yeah.
Is that right? Okay, so, Mr. Treasurer.
Aye.
Aye?
Aye.
Aye?
Aye.
Aye. The
Mr.
the
Chairman,
rules are adopted.
very quickly,
Or the rules are not adopted, the process is.
if the secretary could maybe go through the timeline, I believe we have to have comment open for 45 days, which puts us mid.
Mr. Chairman, Auditor Racines, with this motion, the public comment period will open. A formal one, the one we've done so far was rather informal, and so it's not less than 45 calendar days 45 calendar days from today is November 23rd, which is this Saturday before Thanksgiving. So we may want to leave it open until the first working day of December or so.
All right, Madam Secretary, members of the board, we do have, we are now in a process of taking public comment. The question I have is that we have some comments that came in the interim. I'm curious what the board would like to do with those, make them part of the record, or do we start a new record at this point?
Mr. Chairman?
Madam Auditor.
And this is a little off the cuff, but my knee jerk is that the rules that we have put forward today are
Different.
substantially different than the draft. So my inclination would be to start fresh. Because I do think some of the commentary or criticism that we received we've fixed some of that, for what it's worth.
Is that the consensus of the board? Very good. Thanks.
Mr. Chairman, along those lines, I'd like to inquire the pleasure of the board as far as perhaps making those comments a part of the record for the August meeting. Would that make sense?
Let me ask again. So in other words, what you're saying, because I think we just discussed whether it will be part of the record going forward. You were saying part of the record for August.
Yes, for the special meeting we held.
Mr. Treasurer.
I guess, and before we get those, I'd kind of like to have the statutory citations and the intent and, you know, about why we are promulgating these, what gives us the authority. So I know I'm clear going forward on, you know, and have that analysis also include the, perhaps the Hirschler and the auditorium, okay?
Mr. Chairman, Treasurer, absolutely.
Thank you.
Okay. So the pleasure of the board is to do that, correct? Consensus? Okay, thank you.
Mr. Chairman, are we ready for, my apologies.
Madam Secretary, I guess just because I'm sure there's some attention being directed to that part of the meeting, what is our process going forward? We will post these rules, and can you just kind of walk through that?
Mr. Chairman, absolutely. I may request a little assistance from our Attorney Generals, but I will also refer to which packet was it? The April packet, where I provided quite a lot of that information. My apologies.
Thank you for the donuts, by the way. Or as some would say, crime-fighting power rings.
There you go. So in April, we provided a summary of the steps of rulemaking and also the existing rules and the overview of process. So the agency drafts rules in consultation with the AG's office. We present them to SBC for consideration to begin rules promulgation processes. If approved by SBC, then the agency needs to compile the documents necessary to move forward, which includes a memo to the governor for permission to proceed, a notice of intent, a statement of reasons, a clean version of rules, a strike underscore version of the rules, which we have most of that compiled already. Once the packet is complete, it will be sent to the governor's office for permission to proceed, which should be done within 10 business days. After receiving the governor's approval to proceed, the agency will upload the rules to the Secretary of State's rules system to open the public comment period for a minimum of 45 calendar days. This packet will be the same as the packet sent to the governor's office, except without the memo to the governor. After the public comment period closes, the SBC will need to consider any comments and the rules at another meeting. The SBC will need to vote to adopt the rules. After adoption, the agency must upload the final rules packet to the Secretary of State's rules system within 10 calendar days with a certification page, statement of reasons, summary of comments and responses to comments, clean version of the rules, and the strike underscore version of the rules. To be effective, the rules must be signed by the governor and filed with the Secretary of State's office within 75 calendar days from the date of adoption. There are two other conditions that we've discussed in the Rules Working Group, and here, April and in August, are the conditions of the legislature repealing the governmental meetings and concurrence with Management Council. And I believe the concurrence with Management Council is the issue that we would recommend so that we aren't having confusion for the public about which space they can concealed carry and which spaces they cannot. Otherwise, it becomes a little bit impossible to manage for both the legislative branch and the executive branch.
Well, Mr. Chairman.
Thank you. Mr. Secretary.
Mr. Chairman, I object to that and certainly would think that should be voted upon. This is where this truly becomes recursive. I mean, the governor says that he's vetoing the bill because it's an incursion of the separation of powers. So we're going to have these separate processes. Then we do the separate processes, and we say it has to get a concurrence from a smaller body of just the leadership of the legislature and not an act of the legislature for us to do what we said we're going to do in these rules. That to me is more of an incursion of the separation of powers than anything in the bill, which would have been uniform. So at some point, we just got to quit playing whack-a-mole and just advance the ball here. So I object to that. Is that something we're going to be voting on here?
I don't
Mr.
think so.
Chairman, no.
Well, Mr. Chairman, I would make a motion that we reverse that and we allow these rules to come into effect go into effect once they're adopted, which presumably would be in the, so basically, let me ask a question first. So are you going to, if they don't agree to it in December or January, then are you going to bring forward the rules in February? They just aren't going to be brought forward to us to adopt?
Mr. Chairman, Secretary, I think that's a conversation that's, up to the SBC and the Rules Working Group. We're here administratively to support this effort.
Well, I'm hearing different things. You say you're going to consult with the working group. The governor just said, we're not going to do that. What's the?
We're not doing what? I'm sorry. I think that we agreed to proceed with rules.
Yes.
We did.
And we will take comment, just as we do with all sets of rules, and we will promulgate them in accordance with that procedure. I think there are issues that are in statute, and the Rules Committee knows that, so that is something we can take up at that time. I appreciate your comments, Mr. Secretary, and
Mr. Chairman, here's the question, because I'm very, very confused, and we seem to be getting conflicting answers to this. If we complete the rulemaking process, we just adopted the rules, we just promulgated the rules. We begin the rulemaking process.
that's what we've done.
Whatever it is, 45, 60 days. After that process is over, it should come back to the approving body for a decision on adoption, amendments, clarifications. What I thought I just heard Secretary Norton say is that it will not come back until the Management Council has agreed to something similar so that there will be uniformity. That's what I thought I just heard. Now, am I incorrect?
Let me turn that over to the auditor if you want to address it. I think you addressed that in your meetings.
Yeah, and Mr. Chairman, and please correct me if I misspeak, don't disagree with the frustration, but the concurrence of management council in regards to our passing of rules anywhere where the legislature occupies, it's in statute. And
So to answer the question, I think the issue is we will bring the rules back and we'll vote on them. And then as to the technicalities of how they go into effect, that is left up to the other branch. That was, if I understood you correctly, in statute.
Right, and okay, I won't make a motion then, but that's again why the veto doesn't make any sense, because it's gonna have to be approved there anyway, so.
Mr. Chairman, Otter, I do have that statute handy if you'd like me to read it.
Yes, please.
Mr. Chairman, 9-5-106 State Building Commission powers relative to use of state buildings, rules authorized and exceptions. So paragraph D says no rule promulgated under 9-5-101 through 108 shall apply to facilities occupied by the legislature or the members thereof unless the Legislative Management Council has specifically concurred therein. For purposes of this paragraph, facilities occupied by the legislature shall include those rooms and areas specified in 28-8-112, paragraph A, Romanet I through IV or VI, and other facilities specified by law, or the judiciary.
Mr. Secretary.
Thank you, Mr. Chairman. I want to dig a little deeper into that statute, because I thought the rulemaking was just for the areas that we have jurisdiction over, which makes sense. But I think what that is saying, and maybe you need to give me the reference and I can look at it, is that it's for the areas that the legislature has jurisdiction over. So if we were to pass a rule, I think that's what this is saying, that has to do with areas that the legislature has jurisdiction over, which at least the intent was we're not doing, then I'm not sure that that statute would be triggered the way I read that.
Ms. Monger, do you want to approach and walk through this?
Mr. Chair, and so I just want to go back a little bit to where we are today. And where we are today is that the board has adopted rules. Those rules will go out for public comment. You'll receive public comment and you'll consider that public comment. And at that time, the board will adopt the final rules. And I feel like we're jumping a little bit ahead of ourselves in a couple of ways that are concerning. One is that today is not the time to say what our final rules would be. That means that the public comment process doesn't have any value, and that's not appropriate. So to suggest that right now we should be talking about what the final rules are is really outside the scope of where we should be today. So today we're talking about you already have a motion to put those rules out for public comment. This board can only do what is statutorily allowed to do. So if in the event that there is a statutory prohibition that doesn't allow you to dictate the conduct of certain spaces, the rules, to the extent that they try to do that, are going to be outside the scope of your statutory authority. And so as the governor knows, during that 70-day review process, we have both a review by the legislature that would say whether or not they think these are outside the scope, and that memorandum comes to you in your consideration of signing off on the final rules as the governor of the state, which is your responsibility to do, to determine whether or not they're within the statutory authority of this board. So to the extent that when we get to the final adoption of these rules, once we get through the comment period and you've considered the public comments, we need to address those spaces. I think that's the appropriate time to do it. The rules as they are now, I think, are appropriate to go out for public comment. And so I'm not sure if that answers the question, but I do want to bring us back just a little bit to where we are today in terms of this process.
Mr. Secretary.
Well, thank you, Mr. Chairman. I'm not touching on the rule itself. We segued into talking about the process at the suggestion of the governor, the chairman, in concert with the auditor. And so I'm trying to understand the timeline and the process. So if the rules have to do with the areas that the commission has jurisdiction over, does that statute apply? That's the broad question, and it's not cabined. I'm keeping it cabined from any discussion of the rule itself. I'm trying to understand the statutory interpretation.
Mr. Chair, Mr. Secretary, I think the goal right now, and I would look to the auditor or the superintendent as they worked on these, is to make it apply as much as we can to the areas that this board has jurisdiction over. I think what the auditor has alluded to is the use of the capital is very confusing as to what's legislative space and what's executive space and when, because it shifts consistently throughout, which makes these rules incredibly difficult to say the auditorium is always going to be, a meeting space. It makes it difficult to say when different rooms upstairs are going to be legislative space or they're going to be executive space. And I think that's what the auditor was trying to get to is these rules try to say what we're doing is what we have the authority to do. We are making these rules for the spaces at the times when we have authority over them. And then the legislative space will be its own problem, but I think that's where we're talking about. It's going to be confusing to people that during January to March, these are legislative spaces if they don't concur, and guns can't be there. And in the hallway, it's executive space, but in this room, it's legislative space. I think that some of the sort of the thought is with the way that that's set out is we're trying to just make it so that it's clear we're only doing the space we have authority over. And then if there's additional work by the management committee, then that makes clear what those spaces would be. Does that?
I just have a legal question, and I think it's great. I don't want it to be cabined to the rule at all, Mr. Chairman. If we have the rule apply only to areas that the executive has jurisdiction over, and I think that's implied anyway, even in the, if this rule doesn't, if the final rule did encompass areas that switch at certain times, I think it's clear, and I was in the legislature and wrote that statute in 2019. While it's an inartful compromise, it does, I think, cover the entirety of the Capitol. And so my question is if the rule is touching just the areas that the executive branch has control over, do you think that statute requiring management council approval kicks in?
Mr. Chair, Mr. Secretary, if this board is only seeking to control the areas that you have authority over, then it shouldn't kick in. But that's not the practical, and I think what we're talking about more is the practical issue and not the legal issue. But
And I'm going to see the treasurer. Treasurer, you had.
No, I think I think my questions and comments can probably wait till after the comment period. But basically, I think we may see after that comment period that we're taking care of all of the commingled stuff. And then we might want to go back in and look at what we're going to do in the non-commingled, not only in Cheyenne, but around the state. And so I kind of think this is the right way to do it because you're parsing it out, because I think there'd be too much to actually get everything in one bill or one set of rules. But we may find some legal stumbling blocks one way or the other that we can have the legislature address. And I think after that comment period, a lot of that's going to be a lot clearer.
Thank you, Mr. Treasurer.
Thank you.
Thank you, Ms. Monger. Anything further? All right, Madam Secretary, please proceed. Can I get a cup of coffee?
Mr. Chairman, my apologies if I've lost track a little. Do you think we're finished with?
I
That item?
believe we are. And I think we're on to the rest of the agenda. Thank you.
Thank you. I am going to share my screen, if possible, for the remainder. Oh, and Corey, can you enable sharing, please? Corey, can you enable sharing? It's being slow. Okay, sorry. Okay. I don't know if anyone can see that, but that brings us to tab 3, where I'll review the financial reports. Make this a little smaller. An SBC contingency is the amount that I'd like to focus on today. And the SBC contingency is such an important thing for the executive branch and the State Building Commission as the commission that has executive branch oversight of all state facilities. And in the recent legislative session, the SBC contingency was replenished with $17 million, which allows the State Building Commission to proceed with expedient development of building projects through level 1 and level 2 pursuant to the prescriptive definition of those studies, 9-5-108, for property acquisitions, for emergency repairs to state facilities, and SBC-approved facility repairs, renovations, or upgrades. And so I think in the January SBC meeting, when Dell is back, I would like to provide some additional historical reports and observations about state facilities and state facility management and the slow volley that has happened over time to improve government efficiency and care of our state assets. This $17 million is essentially what allows the State Building Commission to move forward projects that help agencies conduct their normal business that's required by statute. And so this balance here of $23.9 million, we do have a number of things identified that I'll show you the calculations of how that came to be in last year's CapCon request a little bit later. So it's very helpful. JAC has the responsibility to listen to testimony from all agencies and identify opportunities for government efficiency that aren't necessarily so easy to see. And so that appropriation is key for that purpose. The SBC flex appropriation is holding fairly steady at 9.6 million or 11 point, almost $12 million. And the intention of those funds are to assist projects and cost overruns existing state projects. One thing I would like to go back to that I overlooked a moment ago is the SBC contingency. When that narrative and that account was created, it was for the intent for the SBC to maintain $7.8 million minimum balance with 7.45 available for property acquisition. So that covers those two funds. And then the State Facility Inflation Reserve account and the cost escalation de-escalation have not had any activity in the last reporting period.
Thank you.
Any questions about those financial reports?
Questions? Okay.
Item 4, we have both some legal matters and real estate matters to discuss. We will address the legal matters first and real estate second.
And I note in your materials that we might take public comment at this point, Madam Secretary. So let me ask if there is public comment. Public comment? Is there anyone online? Oops. Okay. Thank you. So, Madam Secretary, you were talking about entering into executive session for the purpose of,
Mr. Chairman, yes, on page 31, there is a recommended motion to leave open session and convene an executive session to discuss matters appropriate under the Public Meetings Act.
so members
It's
of
also on the screen.
the commission, I would entertain a motion to that effect.
Mr. Chairman,
Yes, Madam Superintendent.
would move the commission leave open session and convene an executive session to discuss appropriate matters.
Thank you, Madam Superintendent. Is there a second?
Second.
It's been seconded by the auditor. Is there any discussion? Hearing none, all in favor signify by saying aye.
Aye.
We are going to go into executive session. I'll take a moment to clear the room and appreciate you. We'll try to be expeditious about this. Hey. Good, good. Oh, thanks, well, you do too. No, we've had, you can have it over there. I think you were up there and saw how that house fell.
Good try.
Does Brian want to stay for the whole thing, or is he going to come in at time? Brooks, WLEA.
We're actually kind of over our.
Sit here and then the attorneys over.
I should have a better. They could do that. I would have. FSA. Yeah. Well, we have. They want to do on the bottom. Also,
I can get up.
Yep. Password. And I hope you appreciate.
I need to stop sharing, huh? Do I need to stop sharing?
School board of Douglas was considering their own carry policy for the staff. I attend on their meetings. They're doing an excellent job. I don't come down, but yeah, I know that about 75% of my constituents in Douglas will support the idea. So that's consistent with the feedback I got in House Bill 125. But they've done a really good job of being thoughtful about mitigating unintended consequences to make sure it's proper training.
And my concern was, I heard some stuff about, well, this is going to wreck our insurance, some other things. So this gives time to deal with it.
State offices, is that what you're talking about?
Well, just the whole thing.
Okay, yeah, the state, there's so many different layers and complexities, it's kind of hard to put them all in. The state offices, you've got lease space and you've got own space. And so that's kind of confusing. And so there's so many complexities with the layers of approvals and the layers of, so it's like trying to swallow the elephant whole. It was a bit much. So definitely like the Thyra Thompson building presents, because you've got all three agencies, all three branches of government in there. So we're gonna have to deal with that in a particular way. I think we wanna get there, you know. I mean, we get threats in our office, right? He gets threats all the time. I mean, we're lucky that we have
Well, and I think
we have a Division trooper there.
hard to shoot anthrax, but.
But I mean, I didn't like my nose anyway. But anyway, I mean, we're gonna get there. Boy, we just trying to the complexities. You can just see how confusing it is here between legislative space and executive
Oh, sure, yeah,
space.
that's the reminder I have from the school board. I don't want to be perceived as weighing in too much, but part of the reason why 125 got as far as it is, gave more control and